the environmental damage caused by the proposed development, namely removal of trees, destruction of habitat, disturbances of slopes, in the headwaters of the Passaic River Basin to warrant denial of the application or in the alternative modification or the imposition of conditions to the application, which are described in detail in the letter. Now, Mr. Zammataro testified previously. He raised concerns to the Township Committee in November 2021 about the zoning and permitting the zoning, the governing body deferred environmental stewardship of this environmentally sensitive property to as Mr. Brewer indicated, as the board attorney requested us to prepare, give us the opportunity to prepare an opinion letter regarding the board's legal authority to impose conditions on any approvals that the board may be inclined to grant. And in providing our analysis, we've addressed the following issues. One, the board's power to deny conforming applications, that is, applications that conform with your ordinance. No variances requested. To what extent does the board have, if any, legal power to deny such an application? Number two, the board's authority to impose conditions of approval. I think you're probably all familiar with that concept of you approve an application subject to certain conditions, and that before the applicant could receive a building permit, those conditions would have to be satisfied. Three, we addressed the township's ordinances regarding environmental protection and conservation. Four, we do discuss the ordinance in particular with regard to the township's encouragement towards lot size averaging practice, which is essentially clustering development that could occur over a large piece of property and having that development clustered on a portion of the property to preserve environmentally sensitive parts of a larger tract. And five, the legal propriety of my client's requested conditions. And those conditions are set forth in detail in the letter outlined. I won't go through all the colloquy that we did request and did receive. We appreciate receiving the tape of the last meeting, which we had transcribed, so that the colloquy between myself and the board attorney was accurate in terms of how the issues were described. The board attorney raised the Dunkin' Donuts case. And by the way, I didn't know he was going to raise it, but I'm familiar with the case, as the board recalls. I think I said it was a 1982 case, I think it was 1984, my apologies, I got that part wrong, I think I got that right. And, you know, I think that the board attorney can state his position, but based upon what's in the transcript here, that case was cited basically for the proposition that if an applicant submits a conforming application, you have to approve the application. You can't deny it because the governing body has made a policy determination that the development that's being proposed is suitable and appropriate for the area, and indicated that in the Dunkin' Donuts case, in the case of traffic, the traffic volume was not a basis to deny the application. And that's all true. However, as I pointed out, and is correct, is that that's really not the proposition of law that the Dunkin' Donuts case stands for. And there's a lot of cases, or other cases, including the BRB case, the STC case, which I cite in the opinion, that stand for a very different proposition of law, which is well settled in this state, which is that boards do, under certain conditions, have the ability to deny applications that are conforming, that don't require variances. In the Dunkin' Donuts case, for example, which was cited by board counsel, if the board were to make a finding that means of ingress and egress to the Dunkin' Donuts were unsafe, the board could have either imposed reasonable conditions or denied the application. And again, there are other cases that stand for that proposition. So I do not believe that the board is without power to deny or condition a conforming application. And in fact, in your ordinances, chapter 16, emphasizes that reasonable conditions that limit adverse environmental impact fall squarely within the board's jurisdiction. The township code is clear and unambiguous regarding the board's authority to regulate, for example, steep slopes. We'll talk about steep slopes. And specifically empowers the board to impose conservation needs as a condition of approval of a subdivision to protect natural resources of special character or environmentally sensitive areas. And I cite to Township Code Chapter 16-10.BF. That's one of the things that we requested here, conservation on steep slopes. We were a bit surprised that power of the board was questioned in that regard, when that power is right in your ordinance and derives from state statutes that we cite in the letter. Specifically with regard to the ability for the board to impose conditions, we cite the Hoodley case, which is an appellate division case, good law, and that case considered this very question. Basically the appellate division considered two questions determining whether certain conditions were appropriate. One, whether the municipal ordinance prohibited the imposition of conditions, or two, whether specific conditions were arbitrary, capricious, and unreasonable, which I think is exactly what I said to the board at the last hearing. And I think most every land use lawyer knows or should know these basic propositions. That the board does have broad powers to impose conditions, and that the test for those conditions are arbitrary, unreasonable, and capricious. And my letter goes into what that means. With regard to the township's environmental code, chapter 14-7 enumerates express powers of the board. And in exercising these powers, the board must, with its statutory purpose to ensure orderly growth and development, ensure conservation, protection, and proper use of land when deciding an application. And also pursuant to your ordinance, to approve an application, the board must make several mandatory findings regarding an application, including whether the proposed development will have an unreasonable impact. We found other provisions in the code which are cited in the letter which reference best management practices, which is something that was testified to by Mr. Sanders. And in fact, Chapter 16 devotes an entire provision to protecting environmentally sensitive and critical areas. For example, Chapter 16-10.8, subdivision applications must be designed to the greatest extent possible, such that critical areas are undisturbed, where flooding, erosion, etc. could occur. Since the protection of critical areas is in the board's prerogative, it must also consider the use of techniques, including best management practices. The condition that we've requested regarding the submission of the application to U.S. Wildlife was testified to by Mr. Strano, who the board recognized as an expert in habitat assessment. Testified, his uncontroverted testimony is that is a best management practice. That condition is embedded specifically in your ordinance. I mean, I'm doing this work, I'm happy to do it, I feel bad that the residents have to pay me to do it, it's in your ordinance. So based on the above, the board is not only expressly authorized, in my opinion, but required to limit environmental harm when considering any subdivision application regardless of their conforming nature. And by mandating the board to consider the environmental consequences of the development application and equipping it with methods to limit the consequences, the Township Code clearly provides the board with authority to deny, modify, or impose conditions upon subdivision applications that may cause environmental harm. And the township's ordinances in that regard find their basis for legitimacy and legality in New Jersey state statutes, specifically NJSA 40:55E 41. Now, you heard some conversation about lot averaging. And we wanted to point out that lot averaging again refers to clustering development over a large tract onto a smaller part. You wouldn't be reducing the number of homes that would be proposed. Presumably, it would be the same. And for our purposes, we would advocate that it would be the same number of homes that would be yielded over the larger tract. But you would do so and preserve the environmentally sensitive areas. So you would have clustered development. Your ordinance recognizes this. In fact, it is specifically encouraged. Chapter 21-10 states, subdivision developments in the R5 and R10 zones are encouraged to be designed according to the principles of lot averaging in order to promote the preservation of permanent private or public open space, especially areas important to environmental protection. It's right out of your code. And since the proposed subdivision is located in the R10 zone, and uncontroverted evidence that we presented of adverse environmental impact indicates that that averaging is available as an appropriate method for the board to implement. And we want the board, frankly, to do that. So our position, I want to be clear about what our position is. One, we believe that the board has the ability to deny this application based on what I've said. If the board doesn't want to deny the application, and my client is not saying there should be no development on the property. The position is not that. The position is that the property should be, could be developed in accordance with a lot averaging plan. And the applicant should be encouraged to come back to the board with a new subdivision for the same number of homes that would result from this application, but do it under a cluster development concept, consistent with your ordinance. And we believe that the board has the authority to require the applicant to do that. And if the applicant says, no, we're not doing that, well then in that instance, yes, I believe the board has an absolute basis to deny the application. You're not saying to the applicant, you can't develop the property. The board wouldn't be saying that. My client's not saying that. My client's saying develop the property responsibly in accordance with your ordinances, in accordance with state law. And so that's our point. Now, in the event the board doesn't want to do that, we're trying to be reasonable and provide the board with alternatives. In the event the board doesn't want to do that, then we have specified conditions that we would like to see the board implement with regard to this application. And the imposition of conditions would be sort of the third alternative for us. And I would like to just make sure the record is clear in terms of what they are. One is establish conservation easement on the subject property to prevent the development on steep slopes as they're defined in the ordinance. The authority for that is right in the ordinance. You don't have to look very far for the authority to do that. We would edit that. Two, establish tree cutting limitations on the boundaries of lots within the subject property, such that no tree cutting would occur within 25 feet of the side yard or 50 feet from the front yard except the permitted driveway. That is in essence a codification of your existing ordinance. Why do we need that? So, people don't someday decide to change it. You have the power now to codify your ordinance with a condition of this site plan approval that would result in permanency with regard to these conditions. And you have the power to do it. Nobody can make a credible argument that imposing conditions that codify your ordinance are arbitrary, capricious, and unreasonable. That would be an absurd argument for a lawyer to make to win the issue. You're codifying your own ordinance, and that's unreasonable, arbitrary, and capricious. That's just not a credible argument. Of course it's reasonable to do so, and we're asking you to do so that there would be permanency to the restrictions. 3, that you would require the applicant to apply for and obtain tree removal permits from the Tree Preservation and Landscape Committee. And you may say, well, they're required to do that. It's part of the ordinance. You have residents that are a little suspicious, candidly, about how things work in the local government in that regard. I'm just, I'm not testifying, I'm summarizing what has been expressed. By putting this in as a condition, what it does as a practical matter is when the construction official goes to issue the building permit, you gotta check off the conditions. It's really easy to, forget or have an oversight on an ordinance requirement. But when it's here in a condition, somebody's gotta sign off on it. And it adds a level of scrutiny, due diligence, belt and suspenders, whatever you wanna call it, that this would be required. The 4th condition is to require the applicant to prepare a habitat and tree survey to be submitted to U.S. Fish and Wildlife Service for assessment as testified to by Mr. Strano. Again, he was accepted as an expert in habitat assessment. He provided testimony that that's the best management practice. Your ordinance provides for you to use best management practice in this regard. We're not asking you to do anything other than to use your authority based upon the powers, express powers provided to you in the ordinance to ensure that best management practices are followed with regard to the development of this property. I don't think anybody can argue that that ordinance is out of bounds, or inappropriate, or frankly even onerous if you're really balancing environmental considerations as outlined in the ordinances of the township versus the applicant's right to develop the property. And frankly, we think that's appropriate. The applicant frankly should come back with a lot of it. But anyway, the last condition is one that was initiated by the chairman, which we support, which is to prohibit any tree removal or cutting between the period of April 1 to November 15th. We go into additional detail in the letter, providing specific justification for each of those ordinances or each of those conditions. I've summarized those for you. I'm not going to read the letter to you. You can read it, take as much time as you want to read it, deliberate on it, come back next week, vote, whatever you want to do. But the basis in writing is provided even in more detail than what I've just described for the board's power to impose the conditions that we requested. In summary of the letter, the conditions above are really explicitly authorized by Chapter 16 of the ordinance and directly reflect the statutory goals and legislative priorities of the township as set forth in the ordinance. Again, it would be absurd to surmise that the board's actions in imposing these conditions would be considered arbitrary, capricious, or unreasonable by any court. As I say, the board is simply, in most cases, codifying provisions of its own ordinances. Courts have long used the arbitrary, capricious, and unreasonable standard to uphold decisions unless they are contrary to the evidence or established rules of law, which again cannot be the case if the board is acting upon its own express authorities and codifying its own ordinances. So that is a summary of the opinion letter that we provided. I think before going on to my summation, Mr. Chairman, I refer you as to whether at this point you want to hear from Mr. Brewer, or whether you want to hear a summation from me, or whether you want to hear from Mr. Brewer,
But that was your summation.
not in public. Well, as I indicated, if I wasn't clear, I apologize.
And the other reason I think we should keep moving forward with respect to your summation, and then allow Mr. Malman to speak in. If Mr. Malman agrees to everything, then everything is done. so I would.
Correct.
Okay, so it's one of these things where, and he is a very agreeable lawyer, so.
He is, I like Mr. Bell.
So as a result, why don't you continue into, and we'll put Mr. Brewer on the,
All right, so
on the
I
hot
will
seat.
continue with my
Please.
submission and then I'll rest my case. So, in summary, Mr. Chairman, my client objects to this application because of its needless impacts on the environment. Adverse impact on trees, habitat, headwaters of the Passaic River Basin, all of which have been demonstrated in the testimony of Mr. Keller, Mr. Strano, and Mr. Zammataro. But, and I want to say this correctly with respect to that, there's a subtext of these proceedings is also concerning. And it was testified to by Mr. Zammataro, and that is that this local government, at least through the lens of my client, and many township residents who pay attention to these proceedings, that they feel that town really hasn't been straight with its residents with regard to the way in which the ordinance that led us here tonight was adopted. I know that's not before the board, so I say it's a subtext here, it's context, it's important, it's testified to. So I would be remiss in not mentioning it. And it doesn't seem to value impacts of development in the way its predecessors did. That's a sentiment that my client has. Mr. Zammataro again outlined the way in which the Township Committee, from his perspective and that of others, really shut the residents out of the process that led to the zoning that permits this subdivision back in 2021. And according to the uncontroverted testimony of Mr. Zammataro, those residents were told that environmental issues would be addressed by the planning board. And then to hear the board attorney raise questions about board's conditions to implement conditions, which are right out of your ordinance, I think you can understand, hopefully, why residents are not all that happy at the moment, or feel as though the process is not serving them the way it should. And that is an important subtext here to these proceedings. So we're here. Again, we were asked, given the opportunity to submit a letter. I think the board, the chairman actually asked Mr. Brewer if the board could entertain conditions. The answer was no. We've done the best we can to refute that. And again, understand that from my client's perspective, it just appears to fix it in. And I'm not sure that's an unreasonable reference. I don't think it is. The chairman asked for, in our opinion, in our view, it looked like, asked for cover. No, board would grant conditions. No, okay. It's a conforming application. There's no variances. Approved. That's the sentiment. That's the message. That's the feeling. And I'm here to express that. It's important. The board has absolute power to condition approvals. I'm not going to repeat my opinion letter. And I think that the legal propositions that I cited are pretty basic and axiomatic. Most of these attorneys understand them regularly. I think that the Dunkin' Donuts case stands for what it stands for. We went through that. So we think that these issues should be brought to light and dealt with, not in a way that provides cover for just an approval without condition, but a way that raises important issues and powers of the board that should be considered to balance environmental protection, to balance drinking water protection with the development of this project. Again, my clients incurred money paying me to write this opinion. And I think, we're happy to do it. I think a lot of what I said, candidly, while we arranged it, packaged it, researched it, I think a lot of us as lawyers, we kind of know off the top of our head. I represent boards, only in one jurisdiction, Mr. Chairman, but we represent planning boards and zoning boards, and serve as a mayor, and represent mostly developers. I really don't do objective work. I've been laboring in these vineyards for 35 years or so, as the commercial says, I know a thing or two because I've seen a thing or two. And so this is an area that I know. I don't think that it would say that these conditions would be arbitrary, capricious, or unreasonable. So So in conclusion, I think, Mr. Chairman, there would be at least two consequences for not denying or conditioning this application as requested. One would be unfortunate environmental degradation of this property. The second consequence is can't believe I can say it, it's a deepening distrust of this local government. And our plea is simply, is very simple. Do the right thing. Whatever you believe the right thing to be, do it. The right thing is to condition this application the way we've outlined, do it. You know, do the right thing. Consistent with the past practice of distinguished public service in this municipality, like Katie Porter, Jack Schreier, my colleague, on the Freehold Board 100 years ago, well, not quite 100 years. Several years ago, Jack and I led the charge of the Freehold Board to increase the open space fund, and Jack was very proud of his work and the work of Mendham Township in establishing himself in the county as a leader of environmental stewardship. I mean, that's the past reputation of Mendham Township. It is one that local officials take the county with pride in. It has been a reputation of this municipality. So we ask to do the right thing. I think I've articulated what we believe that is. If there are questions of the board with regarding any of the conditions or any of our positions, I'm happy to ask them in the spirit of providing clarity to the board on our position. And I thank the board for your attention to this application, your consideration of the arguments. I know you did a lot of things, you volunteers, you